Once again, thank you so much for joining us for this webinar today on estate tax law. We're here with Steve McDaniel, who's a partner with the law firm of Williams McDaniel. And right now I'm going to turn it over to one of our financial advisors, Amy O'Bannon, who's going to introduce Steve.
I'm not sure that he needs just a lot of introduction. You all are in for a real treat. This will be great. Steve owns his own firm, and we've had a great, Matt and Alan and I have had a great partnership with him and several of his lawyers for many, many years. And we're hosting today Matt Byer, who's our trust administrator officer here, and Alan Ferguson, portfolio manager. And again, I'm the financial advisor here in Memphis that works pretty closely with that group. As I said, Steve has had his own firm for many years, and he's mentored so many lawyers in town and brought up baby lawyers. He's a certified estate planning specialist. In November, he's going to be inducted into the Estate Planning Hall of Fame. He's a past president of the National Association of Estate Planners and Councils, as well as the local Memphis Estate Planning Council. He's taught at the law school for over 25 years. He actually taught Matt in one of his classes. He speaks all over the country and is very sought after. So we're very fortunate to have him here in our hometown and have him here today to talk to us. He's going to kind of talk to us about what's going on in the estate planning world, given the political environment. So we may have some big changes, we may not, but we need to be prepared. And these are things that we can talk to our clients about and help them make decisions based on their family situation. And we'll just see kind of what happens. So he didn't want me to elaborate too much further, so I'm going to let him get started. Enjoy.
Thank you, Amy. Amy failed to point out that I also taught her for 3 years at Southern Trust School. And so everything she knows, she owes to me, or at least a couple of things. When I was first asked to do this, the question that was raised is, where is this law going? It would probably be better if we had this discussion in about a week, because then we might know, but on the other hand, we might not know who the president is. So what we're going to do today is I'm going to do three things. The three things are, one, I'm going to give you a little bit of history of the estate tax law, which I think you'll find hopefully interesting, maybe amusing. It will give you some insight as to where we are and how we got here, and perhaps also where we're going. We'll talk about the proposals that have been presented by the Republican Party and the Democratic Party, and where this estate tax law may go depending on who's elected. Last but not least, we will look at some techniques that deserve consideration in some very uncertain times from an estate planning standpoint, most of which will relate to high net worth people, but not everything. So in that regard, let's get going. The death taxes have been around forever. They go back to Egyptian times, Roman times. In the United States, our first death tax came to be really for the purpose of paying for the American Revolution. It's interesting that inheritances of over $50 were taxed. That death tax was repealed only to reappear again in 1862, once again to pay for a war, the Civil War as the case may be. After the close of the Civil War, the death tax disappeared, only to reappear in 1898, once again to fund yet another war. It then disappeared and reappeared in the early 1900s, but partially to pick up the expenses of World War I, but mostly because of a change in society that addressed, from our standpoint, the fact that a massive amount of wealth had congregated in a very few people, and the purpose of the estate tax was to break up those large concentrations of wealth. If any of you have ever been to Jekyll Island, you had the 50 wealthiest families in the country who descended upon Jekyll Island every winter. They all built homes. That is actually the place where the country was run during the winter, simply because this is where the Rockefellers, the Carnegies, the Vanderbilts, these families went down to Jekyll Island, spent the winter there, and that's an interesting place to visit if you get an opportunity to go visit. Our current version of the federal estate tax goes back to 1916, once again, to pay for some of the expenses of World War I. The extremely wealthy, however, understood that Congress had messed up the first estate tax law, and while they did tax estates over $50,000 in 1916, they did not tax gifts, and it was another 8 years before the first gift tax appeared. That law remained pretty much unchanged until 1948, when we saw our first marital deduction appear. Before 1948, husband dies, leaves the estate to wife, there were estate taxes to pay, notwithstanding the fact that there was a wife. In 1948, we got or received the first marital deduction, and we could exclude up to half of the estate for distributions to or for the benefit of a wife. It's interesting to note that the maximum estate tax rate in 1948 was 77%. Little changed between 1948 and 1976. In 1976, the law was changed to move the exemption from $60,000, where it had been for decades, up to $175,000. Then in 1981, further change in the law produced a process whereby the exemptions began to go from $175,000 to $600,000. We then saw for the first time in 1981 the unlimited marital deduction, which changed everything, because now you could leave the entire estate to a surviving spouse and pay no estate tax. The estate tax, as we know it, turned into a second death tax, as the case may be. It was unnecessary at the death of one spouse to have to tax assets as long as they passed to the surviving spouse. Once again, everything kind of went nowhere until 1997, when the Taxpayer Relief Act moved the exclusion up to $1 million. In 2000, we saw the first significant and serious efforts to repeal the federal estate tax. In fact, Congress in 2000 passed a bill that totally repealed the federal estate tax. The bill was delivered on a tractor to the White House. I joke that was the first time most of the congressmen and senators had ever seen a tractor. President Clinton vetoed the act, and therefore we were left with an estate tax that was pretty much as it had been until the next year, when everything changed. And that change that occurred in 2001 set forth a process where between 2001 and 2010, the exemption moved, and in 2010, the law was set to have the estate tax expire, but it only expired for 1 year. So we had a situation that we discovered, or we saw in 2010, where for 1 year and 1 year only, the federal estate tax did not exist. You had a choice. You could opt in and have a federal estate tax with a $5 million exemption, or you could simply say, no, there's no federal estate tax, and therefore we don't have to worry about it. Winners, if you could call them that, because they died that year, was, for instance, George Steinbrenner, who had an estate in excess of $1 billion. His estate paid no estate tax. We saw a number of high net worth people die that year. They got a windfall. I actually had a client of mine that the family intentionally did everything they could to keep dad plugged up, so to speak, and alive until January 1st of 2010, at which point he died and the family paid no estate tax. 2011, the exemption moved to $5 million per spouse. In 2018, it moved up to $11 million per spouse. The The exemption this year is $11.58 million. The question is, what will it be next year? And the answer is no one knows. If you will look, therefore, the next slide simply shows where the law has changed. In short, it has changed over my entire career. In order to properly plan most estates, you had to tell me what year you plan to die in, what Congress would do, and what your assets would be worth in that particular year. That's the lunacy, if you will, or the insanity in which we've dealt with. So what we're dealing with today, candidly, is nothing new whatsoever. Just to give you a few numbers, in 1976, when we had a $60,000 exemption, 7.5% of all of the estates were subject to estate tax. That number went to about 2% in 1996 when we had a $600,000 exemption. By 2000, there were some 52,000 estates generating some $24 billion in revenue. By 2010, again, no death tax, but the revenues came from 2009 deaths. Because of a $3.5 million exemption, the taxable estates had gone all the way to a mere 6,711. By 2018, and the slide says a 5.49 exemption, that's slightly off, that's my mistake. We're down to some 5,400 taxable estates, which again produced some $20 billion in tax. So what we have seen over the last 25 odd years is we've seen the number of people subject to federal estate tax meaningfully drop. We have seen the levels of tax collected shift up and down over the years. Our estimates for 2020 are some 6,000 individuals or families will pay estate tax, and it'll be about $25 billion. The first thing we learned there is it truly impacts not a lot of people, and it generates, in the grand scope of things, a relatively small amount of money, if you consider $25 billion or $20 billion being a small amount of money. Note revenue from the IRS website in 2018, we had some 5,400 people who paid estate tax, some $20 billion. But the interesting number there is that approximately 1,000 of that 5,400 people paid 14 of the $20 billion. The taxes typically, or the revenue, typically comes from families in the $20 to $50 million range. It always has, and it frankly always will. Gift tax returns. In 2018, there were some 246,000 returns filed. Only some 2,100 actually paid tax, and they paid less than $1 billion in gift tax. It's a lot of returns, and frankly, not much tax to pay. So where are we now? Well, where we are today is there's obviously no tax between spouses. We have in most states, Tennessee specifically, but in most states, no state inheritance tax. The states which have an inheritance tax, New York, New Jersey, etc., are the states that a lot of people are trying to get away from in their retirement years to avoid those inheritance taxes. We now have an $11.58 million exemption, which if not used by one spouse, or if not needed by one spouse, can be transferred to the surviving spouse simply by filing an estate tax return. Furthermore, so that brings us to where we are today. And the IRS has declared there will not be a clawback. Well, what is a clawback? Well, the big fear is two things are going to happen. First of all, under the existing tax law, the one that is out there right now, in 2025, the estate tax exemption is supposed to revert from the $11.58 million back to $5 million. It will be adjusted for inflation. It'll probably be about $5.5 million. But in 2025, the estate tax exemption is supposed to be reduced. But then the question comes up, what's going to happen in 2021 after the elections? So where we stand here today is the IRS has said if you use your exemption today, that is your $11.58 million exemption, and if the exemption then falls back to say this $5 million number, we will not be punished or penalized retroactively for using the exemption today. And therefore, there are multiple articles that have been published in the New York Times, the Wall Street Journal, Forbes, that all suggest that people should consider, especially high net worth people, using their exemption today, because if it reverts back to a smaller number, and if one's estate is larger than that smaller number, there will be taxes that will be incurred, but if we use the exemption today through gifts, we'll not be punished for using our exemption. Excuse me. So what are the proposals? Well, the Republican position is really pretty simple. For a decade or more, actually 20 years plus, the Republican Party has been for repeal of the federal estate tax. We have actually been within 1 or 2 votes on at least 2 occasions where the estate tax was going to be permanently repealed. I think politically that is probably out of the question today simply because of deficits. It's comical, if you will, that the reason for killing the death tax, so to speak, is this is to help the farmers, this is to help the small business people. The other argument is it doesn't produce any meaningful revenue. If you believe $20 to $25 billion is no meaningful revenue. On top of that, the public, by and large, it opposes a death tax, as the term has been coined. So what's the Democratic position? We wish we knew. And I'll get into that in a little bit in just a second. But the truth of the matter is we don't know for sure. One bill calls for an exemption of $3.5 million. Elizabeth Warren promoted a wealth tax. Bernie Sanders wanted to tax estates of over $1 billion at 77%. There are so many miscellaneous positions out there, or differing positions out there, that it's very difficult to know where the Democratic Party truly is. The Biden position is equally difficult to follow simply because if you go onto the internet and you start looking at what the position is, you're going to find multiple different answers from multiple different sources. We do know that the Biden-Sanders Unity Task Force that issued a document in May of 2020 that said estate taxes should be raised to their, quote, historical norm. Well, they never defined historical norm for us. We don't know what a historical norm is. Historical norm since 1916 or a historical norm over the last 20 years? Will it be a $3.5 million exemption, a $5 million exemption? Will it be a $600,000 exemption? We simply don't know, although I will share with you that the $3.5 million exemption seems to be the one that carries the most comments, that seems to be the number the Democrats have begun to settle on. More importantly, what will the tax rate be? Will it be 70%? Will it go back to where it was some years ago? But there are other issues that are more important, and the number one, or just as important. The number one thing about the estate tax is at my death, if I leave assets to my wife or my children, and I have investable assets, we get a new basis in those assets equal to the fair market value on the date of death. Therefore, if I bought stock years ago and I paid $1,000 for it, and at my death the stock is now worth $10,000, all of the built-in capital gain on my stock disappears. We have what is referred to as a step-up in basis. At least that's the term that's typically used when the market is going up. Biden's position very definitely may be directed toward losing the step-up in basis. We don't know what this truly means. We don't know whether it would be a loss of a step-up in basis for estates over a given size. So there are really 3 things that could occur here. One, we could see an elimination of the basis adjustment at death, and there would simply be no adjustment to basis at death. Well, guess what? Congress did that in 1976. It was an unworkable law, and in 1981 they repealed that. Second choice would be to eliminate the basis adjustment at death and have an immediate capital gain tax. That's kind of like the Canadian system. It's interesting that depending on what the capital gain rate is, if that's the tax we are left with, you could actually see the tax liability for some of the wealthiest families in the country come down. Because if the capital gain rate is in the 20% range, the estate tax rate is 40%, you could actually see with an elimination, with a deemed capital gain tax at death, you could actually see that death tax consequences come down for some of the wealthiest families. Third option is the worst of all three. That is to eliminate the basis adjustment at death. Again, this was done in 1976 and repealed in 81. Have an immediate capital gain, but also have an estate tax on top of that. That could be a little scary. You need to remember, however, that lobby money is the king. Millions of dollars have gone into lobby efforts over the last 30 years trying to get Congress to act as the lobbyists have desired relative to the federal estate tax. I know from some personal knowledge that massive amounts went to Congress to lobby for the repeal of the estate tax some years ago, and that repeal fell short. The Tax Foundation did a survey that found 2/3 of the population are for repeal of the federal estate tax. I suppose, given the fact that less than 1% of the population pays this tax, I think most people think they're going to win the lottery. Congress might also decide to kick the can down the road again. They might decide we're going to do this for the next X years, and then we'll worry about the estate tax some years from now. So what does all this mean? Well, it means it's 0.17%. That is 1/5, essentially. 1/5 of 1% of taxpayers actually will have to pay federal estate tax. That number could obviously go up into the 5% range if the exemption drops to 3.5%. Therefore, it's not about taxes anymore. It's really never been about taxes, although estate taxes drove the train for years and years. The estate taxes don't drive the train anymore for most families. It's about leaving a positive legacy. It's about protecting and preserving the family wealth. It's keeping the assets away from the in-laws, as the case may be, in the event of divorce of the children. It's getting the assets to the grandchildren. It's protecting things for the family. So today it's all about basis. It's all about getting assets, adjusting basis at death. And if that is addressed under a new administration, that's going to change the whole picture of where we are. Everything gets a new basis other than retirement money and a few other assets. One thing for those people who are either Tennessee residents, or you don't have to be a Tennessee resident, you simply have to have a Tennessee trustee. And obviously, this is a Tennessee trustee here whose offices I'm sitting in. That is, Tennessee has what is referred to as a community property trust, which gives us a special provision under the tax law that lets, regardless of whether the husband dies or the wife dies, the surviving spouse gets an adjustment in basis in all assets. It's certainly something worth looking at. It maximizes basis. So what are some of the things we might do? Well, consider the case of a client of mine who is providing for his parents. And I asked him, I said, what are you spending on your parents a year? And he said, I'm spending $100,000 a year on my parents. I said, let's create a trust right now. Let's let you put assets in this trust. So we've created a trust. We put $3.5 million in the trust. It will throw off the necessary money to provide for the parents for life. We will structure the trust assets so that they are protected from claims of creditors. They can be used for the parents. At the parent's death, those assets will not be subject to estate tax. However, they will, because of provisions we put in the trust, the trust will get a due basis at the death of the parents, when the assets will then flow down to the grandchildren. And so we take low basis assets, we put this in a trust for two parents who are in their 90s. We will provide for the parents for life, and then we will move the assets on down to the grandchildren at a new basis equal to the fair market value at the time of the grandparent's death. We're simply, and number two, we've also removed this $3.5 billion from the parent's estate. So we've accomplished everything. We've actually saved some income tax because the earnings from the trust are taxed at the parent's rate as opposed to the client's rate, who's in a maximum tax bracket. Everybody needs to remember that we obviously have gift tax exemptions. We can, the IRS does not count gifts of $15,000 per donee, and we need to, in all estate planning where we've got significant assets, use those exemptions by making gifts to the children and grandchildren. Another technique that has gained a lot of footing, especially with the uncertainty of what should we do with these exemptions. Should we use it today? Should we use part of our exemption today? And the number one tool that seems to make sense here is a thing called a family gift trust. They're also called SLATs, if you should Google that. And it may, in some respects, almost be too good to be true. So let's use an example. And since I'm looking at Amy, I'm going to make Amy my wife for just a minute. I have a significant estate. I am concerned that I am going to lose my exemptions under either the Biden administration, should they win, or in 2025, when the law kicks the exemption back down to $5 million and Congress has done nothing. So I create a trust for Amy, and I can gift any amount I want into that trust. And so let's just assume for the fun of it, I gift my entire exemption, $11.58 million, and I put it in a trust for Amy. I put it in a trust for our 3 children, and Amy is entitled to the income if she needs it or for her health and support in her accustomed manner of living. Amy can distribute the income and the principal out to our children for their health, education, and support. This trust is protected from claims of my creditors, assuming that I did not do it to defraud any creditors I have today. It's protected from Amy's creditors. It's protected from Amy's new spouse after my death. It is protected from the children's spouses. It's protected from death tax at my death, protected from death tax at Amy's death, protected from death tax at the children's death. But what are we likely to do with this? We're likely to invest these trust assets, and we hope they grow. Amy's quite a bit younger than I am, and therefore Amy's going to live a long time. And after my death, the trust continues on for Amy for her lifetime. And let's just say it doubled during Amy's lifetime, or even tripled during Amy's lifetime. Those assets are all excluded from Amy's estate. So if this trust started with $11 million and grows to $22 million or grows to $33 million, it is out of my estate because we did it now. We used my available gift tax exemption now. And because the trust is so structured that we do not have to worry about what happens to the growth of these assets. Those assets will never be subject to estate tax at my death, my children's death, Amy's death, my children's death, or even my grandchildren's death if I wish to structure it that way. Sometimes we call these trusts generation skipping trusts. Another type trust, and there are a couple of them in Tennessee, are asset protection trusts. Everybody's worried about asset protection. But the one thing I typically cannot do is I cannot create a trust for myself and shelter it from my creditors. That's the way the law has been going back to the formation of this country. That's the English rule. But we're fortunate in that Pinnacle is a Tennessee-based trust company. And we're fortunate in that Tennessee has some of the best laws in the trust laws in the United States. The best trust laws in the United States are, if you want to look at the states that have the best trust laws, it would be Alaska, Nevada, South Dakota, Delaware, and Tennessee. They're the big boys. We have some of the most progressive trust laws in the country. For the last 5 years or so, 6 years, I taught trust law at the law school. When I went to law school, there was no such thing as a trust law class. Well, trust law is now extremely important, and we have 2 types of asset protection trusts available to us here in Tennessee. That once again, all we need is a Tennessee trustee. We don't have to have a Tennessee resident to make this work. Therefore, the bank can serve in a trustee capacity. The first is a Tennessee Investment Services Trust. It is a trust that's irrevocable. It can be created today. Once again, this trust is distinguished because it is a trust created for me. It's a trust that I can create for my wife, my children. The assets are sheltered from creditors. The assets are not excluded from my estate at my death as a general rule, but they would be excluded following my death if we properly structure the trust from death taxes at my wife's later death or the children's later death. The second is a trust that is absolutely unique to Tennessee. It's referred to as a Tennessee by the entirety trust, and it is a joint trust between husband and wife. They create this trust, and the assets in the trust are sheltered and protected from the creditors of either spouse. It may not be necessarily be protected from the creditors of both spouses, but is certainly sheltered and corrected from the creditors of either individual spouse. We have seen, I suppose our biggest group of people who find this sort of trust attractive are physicians who are worried about malpractice actions, individuals who have just sold their business and wish to put aside a piece of the proceeds from the sale of their business in an asset protection trust and thus protect those assets from a rainy day in the future. These trusts have application to those types of individuals. They're not easy trusts to do. They require following the statutes to the letter, but in the end, these trusts provide asset protection that's otherwise not available. I want to touch on what's called a GRAT, kind of just ever so briefly. A GRAT is a concept that we sometimes call the Walton GRAT, simply because the Walton family made these types of trusts famous. And what it really is a situation where you give assets to a trust and you get the assets back over the term of the trust. The term of the trust might be 2 years, it might be 5 years, it might be 10 years, it can be longer. At the end of the GRAT, if there's anything left in the trust, it's going to go gift tax free to the children. So let me give you an example. The IRS interest rates we're required to use in October are 0.4%. And what that means is any investment in the trust assets that exceeds 0.4%, virtually nothing, will ultimately pass gift tax free to the beneficiaries. So let's assume I create a GRAT for my children and I put $1 million worth of stock in the GRAT. And let's assume that it is a 10-year GRAT. Over a 10-year period, I will get back the stock or the $1 million plus interest at 0.4%. But let's assume that this stock outperformed the IRS assumed rate, and let's assume that it secured a 5% return over the 10-year period. Over the 10-year period, I get my $1 million back plus a little bit of extra, but how much is left in the trust? Well, it could be $500,000 in that scenario, which is available to the kids and goes to the kids at the end of the term. So what does all of this mean? Well, all of this means, one, that the death tax law is likely going to change. It's likely going to change regardless of who's in the White House. We can be and probably should be proactive. If we are concerned that the estate tax exemption is going to go down, then using that exemption today produces no downside to us, because if we use the exemption today, once again, there's no, quote, clawback going to occur according to the IRS, and therefore moving assets out of my estate, there's no downside to me. Assets that I gift away do not get a step up in basis at my death, but once again, Congress may eliminate that step up in basis, so why not gift it away, especially if it's for the benefit of a spouse, but also if it's for the benefit of children perhaps. We can put it in a trust and shelter it and protect it from creditors, divorces of our children, et cetera, et cetera. There simply is no downside as long as we retain enough to take care of ourselves. Keep in mind that from an estate planning standpoint, we prepare estate planning documents and there is a tendency to put them away and forget them. My wife forced me to redo my documents about a year ago. Why? Because they were, believe it or not, 15 years old. Kids grow up and change, or worse, kids don't grow up or kids don't change. The biggest problem is we get older and we may get senile. I've had clients say, oh, I'm going to change these documents later, only to learn that the client is no longer capable of changing the documents at a later date. Keeping plans current is probably the most important thing we can do. So what do we learn? Excuse me. We learn that the tax law changes, but your estate plan doesn't necessarily change. One of the worst examples of this I've ever seen is an individual who wrote his will. He wanted to leave the amount that could pass tax-free to his grandchildren, to them, and leave the balance of his estate to his children. When he did the will, or prepared the estate plan, the exemption was $1 million. He had a $5 million estate. He left $1 million to his children, with the balance to his daughters. So they would have gotten $4 million. But two things happened. One, he had a massive stroke and he was no longer competent. The estate tax exemption went up. It went up to $5 million. When he died, the $5 million, because the document said, give my grandchildren everything they can get tax-free, they got virtually the entire estate, leaving virtually nothing to the daughters. Well, obviously, that's easy to fix, people. We just get everybody in the room and ask the grandchildren if they'll sign over documents and giving money back to their mothers. Guess what? One of the mothers got distributions from her children. The other grandchildren simply said they were more important than their parents, their mother. And we have a total mess. Our assets change over years, and our estate plan doesn't necessarily change. We will die, but if we don't, we will get old, and will we be competent, and who's going to marry our finances? I could speak for hours about the problems we're seeing today and the conflicts we're seeing with families over who gets to manage daddy's money when daddy is no longer competent. Documents have to be flexible. Documents, we can't know what year we're going to die in. We cannot know what the law is going to be, and we will not know what our estate is necessarily worth. Therefore, keeping a plan current is important. It's the old statement, those who fail to plan to fail, and nothing can be further to the truth. With that, I've said all I need to say. My 40-something minutes is about up, and if there are any questions, I'll be happy to try to address them.
Hey, Steve, we do have a couple questions that have come in. One of them is, what is the downside or the risk to setting up a spousal lifetime access trust?
There's one downside. I'll go back to my example with Amy. I set up the spousal access trust for Amy and the children, and then Amy leaves me for the pool boy. I have created a trust for Amy. It is hers, and I probably have no right to claim any part of it in the event that she divorces me. So I want to have a good marriage here before I do this. A second possible problem with this sort of trust is I create this trust, and let's just say for the fun of it, let's just say I have $30 million or $20 million. That's a nice round number. And I put $10 million in this trust for my wife and children. But I then have a financial reversal, and the money I have retained in my own name, I had, give you a good example. I had, in my own name, I kept my Sears Roebuck stock. And that Sears Roebuck stock has plummeted. And it's now Kmart, but it's worth less than it was. And I don't have enough to take care of myself. Again, this trust is for the benefit of Amy and the children. And this is not a trust that I technically have any right to. Now, we can hedge that bet by giving Amy a power at her death to direct the assets back to me. Well, if Amy exercises that power in my favor, we've probably destroyed all the estate tax benefits that we sought to create. But if we've had a total financial reversal and there's nothing left to take care of me, there's nothing that stops Amy from giving some of it back to me in the event of her death and allow me then to continue living in the manner to which I've become accustomed.
All right, we have one more. Does the no clawback provision mean portability transfer to a surviving spouse for a death that occurred before 2021 will be preserved for the death of the surviving spouse who dies in 2021 or after?
I wish I knew. Okay. We think that if my spouse dies and because of the portability elections are available and I inherit my spouse's exemption, we believe that that exemption is frozen, and even if the estate tax law changes, that cannot be taken away from me. I think that's what everyone believes, but we don't know how they're going to change the law in the future. And could they change it and take that away from us? Yes, they could, but I think it's safe to say that if I inherited an exemption from a spouse by reason of the portability provisions, I will not ever lose that exemption. And therefore, it is imperative for most at this point, in the event of the death of a spouse, that a federal estate tax return be filed and that portability be elected, even if we think we will never need it, because we can't know what's going to happen to this law after Congress gets through with it, and we can't know what's going to happen to our assets. So we recommend making that election every time it's available, with the hope and expectation that we will not need it, but if we do, it should be there for us.
All right, and we have one final question, I think. Let me just check. Okay, this is a scenario question as well. I have 3 children, one of whom has special needs and receives federal aid for the disability. So how should I set up his funds so that he doesn't lose his disability aid?
Well, you've got to ask yourself a massive question here, and I've dealt with this with some clients. You obviously, as to the special needs child, can create what we call a special needs trust. And a special needs trust is there for the sole and exclusive purpose of maximizing governmental benefits. And that sounds fine, and it is fine, but understand that a special needs trust substantially restricts what can be used for the benefit of a beneficiary. I'm thinking in this situation of a client of mine. There are 3 children. One of the children is a Downs child, and unfortunately, because of issues the child has had, she's severely disabled and incapacitated. And we discussed the possibility of using a special needs trust for that child to maximize governmental benefits, but the client ultimately said, no, that's not what I want to do. I want to provide for this child. And I have enough money that I don't have to rely upon governmental assistance. and I'm going to create a trust for the benefit of this child, even if it causes me to forfeit the governmental assistance that's out there. I think a lot of the decision-making process that has to go on here is how much money do I have? Can I provide appropriately for this child for the child's lifetime? Or do I want to try to maximize governmental benefits with the realization that the amount that can be distributed to or for the benefit of the child out of the trust is going to be pretty severely limited? Obviously, if I've got, let's just use a couple of numbers. Let's just say I've got $500,000 that I wish to put in trust for this special needs child. If that child loses the governmental benefits, we could go through this $500,000 in 2 or 3 years, a couple of years. So in that situation, the special needs trust seems to make a lot of sense. On the other side of the coin, the client that I'm referring to, that child's going to have about $10 million. Well, we don't need governmental assistance. We don't need governmental benefits. We want to take care of that child, see that she gets the best of everything, and at her death, whatever assets are remaining can go to her siblings. Special needs planning is tough. You've got to figure out what your goals are for that beneficiary. Do you wish to maximize governmental benefits, or can you provide, or can you best provide for that child without relying upon governmental benefits? It's a hard question. It's a tough one.
Okay, we did have one more come in, and it's a good one. So this is the last question, I promise. A parent wants income from and control of their assets, but children are worried that the parent may remarry. Best suggestions to solve both issues.
I have won more steak dinners with clients where mama has died and survived by dad, that I will tell my clients, the children, that dad will certainly remarry. People that know me on this call know that I refer to the women out there as the casserole ladies. They descend upon dad. Shortly after mom has died, they're also called pew stalkers. They surround dad at church, and within a short period of time, dad remarries. So what can we do? Well, one, a plan can be structured so that it becomes irrevocable at the death of one spouse and makes it impossible for the surviving spouse to leave those monies to a new spouse, as the case may be.
The casserole lady.
The casserole lady. On the other hand, it can easily be dealt with in a lot of cases with a premarital agreement, but you've got to convince daddy of the need to do the premarital agreement, and even then, there's nothing that stops dad from going in and changing his estate planning documents. I am currently dealing with one of those right now, where mom died. Daddy has taken up with, moved in with, if you will, a slightly younger woman. She's only 24 years younger. And the children are absolutely going nuts. And there is not a lot that can be done because dad had assets in his separate name, in his revocable trust, and he can do whatever he wants. So once again, can you get mom and dad, while they're both alive, to structure a document that becomes irrevocable at a first death? That comes with some tax issues, but the answer is yes, you can do that. And in the process of addressing those needs, it requires educating dad, it requires getting assets into an irrevocable trust, and it's the most difficult thing any children will ever have to deal with relative to a father in the event of death of mother. The husband dies, wives rarely remarry, and when they do remarry, they take care of their kids. They rarely, I am aware of one and only one client that I have and have dealt with in the last decade or so, where the husband where the husband died, the wife is now remarrying, and she is making provisions to leave half of her estate to the husband. I'll be honest, I have never seen that occur before, and she's just going to leave him half of the estate outright, not even in a trust. She says, I want him to have it. And her children will go absolutely nuts should she die, but that's the only one of those I've seen. It's typically, we get in trouble with the dads after mom's died. That's been my problem. And that doesn't say a lot for us men.
Well, Steve, we do have a couple more questions, but I'm just going to ask you those offline, and we can send those back out so that our guests can go ahead and get back to their day-to-day. But we really appreciate you sharing all this information with us. As a reminder to those that are on the webinar, be sure to consult your estate planning attorney for your specific situation, because as we've seen during the Q&A, there's lots of different scenarios out there. And we do appreciate your time today and for joining us for this Pinnacle webinar. We appreciate it.